Afternoon, everybody. Just letting all the numbers come in. A few more joining, so we'll make a start any minute. There we go. Okay, lovely. Well, thank you all very much. I'm sorry if I look a little bit panicked. We just had some last-minute IT issues, as always happens with these sort of things. So Tony's probably slightly relaxed now that he's seen me return to the screen. But yeah, I think my computer decided to do an update at what is it now? So 12:58. I think it decided to do an update. So a quick change of room, but we're good to go. So welcome to this joint presentation for myself and Tony on the subject of resolving workplace disputes, particularly from an employer's perspective. So I'll just jump on. So here is us. If I say a bit about myself, Tony, then we'll come to you if that's okay.
Okay.
So I'm a partner here at Machin's. I head up the employment and immigration departments. If you have a smartphone and you hover it over that QR code on the screen right there and take a picture, you'll be directed through to my LinkedIn. So if you'd like to connect, please do. Always happy to receive new connections, and you'll see that I post quite a lot about updates in employment law and a few updates about immigration as well, although they're not quite so frequent. So please do follow me or connect with me. That'd be great. Tony, if you don't mind saying a few words about yourself.
Yes, thank you, David. Yeah, hello and good afternoon, everybody. So I'm an independent ACAS accredited workplace mediator. Also a maverick thinker who never accepts that this is what we do here is the final word, as you'll be seeing a bit later. So in my police career, maverick thinking was positively discouraged. I was an internal mediator, but I wasn't trusted to be independent and respect confidentiality. And I think that's a challenge many of the HR colleagues can recognise. So for me, there's always a better way of doing things. We just need to find it. So
thanks very much, Tony. So just to say a few words about what you're going to hear from the two of us today. So as we said, the focus of today is about avoiding disputes, but we're going to be covering that from both before, sort of well in advance of an employment tribunal in the early stages, I suppose, if you'd call that, in terms of ACAS conciliation, and then through to tribunals. But the focus is very much on the principles of mediation and things like ways of resolving the workplace dispute, so bringing the relationship back. And obviously then if it doesn't work out, we're going to be talking about how you might try and resolve those disputes, possibly when the relationship has become irreconcilable. But I'm going to hand over to Tony first of all, who's going to talk to us about the much more positive angle, I think, Tony, if we look at it that way, of how you can try and save a relationship rather than what to do once it's broken.
Okay, thank you, David. So good afternoon again, everybody. So yes, as it says, avoiding the costs of employment tribunals. So the British Chamber of Commerce estimated the average cost of an employment tribunal at £8,500. I know, as I've had a sneak preview, that David's costings will startle you. All right. So human costs are actually incalculable, both in our business and our private life. So what price do you put on broken business relationships with others and the organisation? So the view of ACAS is that prevention of workplace conflict is impossible. However, mitigation is doable. And my way of thinking is that managing people effectively and fairly is the key to mitigating workplace conflict. So there's three particular traits for managers that I think fit into this. The first is knowing your people. So for example, I will always say the role is not the person. So another phrase I use is leadership is knowing ourselves and those we're responsible for as people, and behaving accordingly. The next trait is about authenticity. In other words, being natural, being yourself. That breeds credibility, trust, and confidence, all very essential. The third one, which is the real killer where it's lacking, as you'll hear later, is do not procrastinate. So in my direct experience, time is absolutely not a healer. So resolutions such as grievances, disciplinary proceedings, and ETs are win-lose at best. Just think about the amount of time for managers, people teams, and those who are involved. So when we talk, for example, of alternative dispute resolution processes, such as conciliation and arbitration, mediation is absolutely the best form because it's win-win when it's successful. Next slide, please, David. Thank you. Right, the chrysalis method. So as a maverick, I felt I could improve upon the ACAS system of workplace mediation. So these are some of the aspects that I've considered, which I'll invite you to reflect on. So all other workplace mediators first meet participants either online, by email, phone, or at the individual meeting. So the individual meeting is when the mediator and the participant will discuss the matters at hand. But I don't do that. Why is that? So I put the interests of traumatized people at the heart of the process. I recognize the importance of repairing fractured or broken business relationships between the participants, but also organizations. And so my process actually helps organizations conduct effective root cause analysis of their workplace conflict and mitigate those costs. So there's some principles that underline this. So with due deference to David as a lawyer, I never have a brief about the conflict. I just have the names and contact details. Now, the reason for that is so that I don't have a subjective view as to what the conflict's about, which would influence my required fairness, impartiality, neutrality, and objectivity. And it's always in person. Now, the reason for that is those mediators do online mediation. I feel that they have a challenge in that confidentiality absolutely cannot be confirmed. And that's a key element. Later on, when the conflicting participants are together in a joint meeting, of course, if it's online, a bit like our meeting now, is we're not actually in the same space. And that's a key element to prove that a mediation has been successful. I'll always have a mediation in a neutral venue, quite often a golf club, for example. Again, other mediators will do it in the workplace, either literally in the workplace or an office that's associated with the business. I don't do that. Now, quite uniquely, I also have an icebreaker stage in person to create authentic rapport with people who are invariably traumatized. You'll notice I keep using the word traumatized, and I'll explain that. As always, I use the term participants, again with due deference to David, not parties, because that's an adversarial term to me. And always have ground rules to ensure respectful listening at joint meetings. As I said earlier, is that you could either have what we call the dynamics of power, a mismatch of role amongst senior people, or you've got people who for years, and that's my direct experience, have never been able to be in the same space other than in a conflict position. So the ground rules are agreed separately at the individual meetings to enable people to have a safe space for respectful listening. Now, with the ACAS method, again, we always have a written agreement where we've had a successful mediation. The purpose of that is actually to confirm the success of the mediation to the participants. And when they choose to share it, for example, with people teams, that assists governance. So for me, I'm always working with conflicted senior teams. Now, the benefits extend to this. The organisation does not lose valued senior team members. The organisation benefits from the repair of fractured business relationships, resulting in improved morale and performance in their teams. The organisation also does not have to undergo a costly recruitment process, and the brand and reputation of the organisation are not damaged at an ET, which David will be talking about later. So I'll give you a story. Sounded a bit like Max Bygraves there, so apologies. Right, so in the icebreaker, that's where I actually meet one-on-one in a neutral venue with the individual participants. In that icebreaker, we absolutely do not talk at all about the matters relating to mediation. So in this particular case, we involve 6 senior people. Now, one of the participants, a lady, she presented to me in an extremely traumatized state. The whole situation had been going on between the 6 for about 3.5 years. Now, she told me at that time she was 34. Why that was relevant will now become obvious, because I said to her, what's your previous experience of mediation? It's a regular question that I'll ask. Then she said, 17 years ago, when she was 17, she was being mercilessly bullied at school. So the headmaster took her and the bully to his office for mediation, as he said. So I said, what did that look like? So she said, the headmaster sat in the corner, I sat opposite the bully, and for an hour, the bully shouted and swore at me. At the end of that hour, the headmaster looked at his watch and said, right, that's mediation done. So I clearly looked quizzical and I said, what happened then? She said, well, we were ushered out and then the bully beat me up again. So for 17 years, I've been terrified that even to hear the word mediation takes me right the way back to that horrible situation. So after I'd signposted her as to how the process works, she said, I cannot thank you enough. You could see the stress melting away from her because she realized that what she'd been subject to was not authentic workplace mediation. Next slide, please, David. Thank you. All right. So ACAS estimate the cost of workplace conflict in the UK as £28.5 billion. Now, that comes from a 2021 report. More recently, they've described the cost looking another way, and this is all financial, by the way, first of all, £4,000 per employee. Now, that's not £4,000 per participant, that's £4,000 for every person in your organisation. This is an annual cost. So, what are the costs in your organisation? How do you calculate them in your organisation? So how I came to develop this root cause analysis process where I work with people teams was this, that it was good, clearly, to adopt mediation, but very much that was dealing with a symptom. And that didn't sit well with me, because as I've said previously, I always think there's a better way. So part of that better way is working with people teams to actually conduct that root cause analysis. So work in partnership with people teams to help your organisation mitigate and manage those costs. So I'll give you another little example. So there was 2 directors who were directors of a organisation of 2,500 people. Right, for 4 years, I will repeat it, 4 years they'd been in conflict. So you can just imagine the corrosive impact that had on team performance and morale. And again, what happens in situations when eventually organizations think, well, let's give Tony a ring, and it was exactly the same in that previous example that I gave you, is external partners got fed up really at their external meetings with the behavior of these two people who couldn't stand each other. Now, the issue of what caused the problems, that's not germane here, but at the end of the joint meeting, both participants said to me, if only we'd had this 4 years earlier. 4 years earlier. Quite shocking. Next slide, please, David. Thank you. Right, so as it says there, the benefits of early mediation. The earlier appropriate discussions take place between managers and those people in conflict within their teams, the better the chances of a successful informal resolution to that conflict. Trust and confidence in the manager benefits everyone and the organization. So my contention is awareness by managers of the unique benefits of independent workplace mediation empowers managers to have the confidence to consider this option at the earliest opportunity. Really can't stress that enough in terms of importance. So mitigating the human costs of broken business relationships is incalculable, and it's invaluable to people and their organization. So repeat again, the organization is protected from the damage caused to its brand and reputation at employment tribunals, and David will talk more about that. Above all, you protect the business relationship between the participants in mediation and the organization. So what is that worth to you and your organization? So I'll give another little story. So this involved two senior union officials. Now, they were formerly friends. In fact, they were formerly neighbours. The families went on holiday together. The blokes went to football and played golf together. They were really good friends. Now, the conflict had deteriorated to such an extent, and again, this is after a number of years. I really can't stress this enough. You know, I get called in to deal with mediation after years of stress. Okay, so it reached the stage so that some of the people who are on this webinar may think about football matches, for example, and this is quite true. So when either of those senior union officials came into a canteen area or a common area, there was either cheering or booing, right? It reached that stage. And the impact on productivity within the union, let alone the organisation, was significant. Now, during the individual meeting, when I asked the question, think of a time when things were good between you guys who were friends. And then at one individual meeting, the participant said, after a bit of thought, he said, well, after I sent a WhatsApp message as a bit of a joke to my friend. I never got a reply, and things started to deteriorate from then. Right. So the difference between a mediator is I could not go to the next individual meeting and say, guess what I've heard from that person. Now, if I was a conciliator or an arbitrator, I could do. So the first time these guys who are in their late 40s realized what had actually caused the wreck of their relationship was in that joint meeting. And I say these are guys who are in their late 40s. And why that's important is that the joint meeting is the most emotionally charged part of mediation. This is when conflicted people actually get together and the safe space for respectful listening is kept via the ground rules we've admitted. So when the WhatsApp situation was discussed, there was tears, there was hugs. I mean, it's quite emotional even to think about it now, because wow, It was really strong, and they were hugging each other. Now, I don't know what sort of price you can put on the human side of that. In terms of the business side, massively significant. The union were really happy, as were the organisation. But for me, most importantly, two people, their families, could properly get on with their lives. And that's the power of what authentic workplace mediation can bring. So next slide, please, David. I think it's over to you.
Thanks very much, Tony. So yeah, that's an excellent summary by Tony there of the importance of trying to rescue a relationship. And I have to say, a lot of clients, certainly by the time they're coming to see a lawyer, have probably already reached that point where they consider the relationship is irreconcilable. I think hopefully what you would take from Tony's is that that's probably misconception. Would you say that's right, Tony? I think probably a lot of people might think that a relationship has become irreconcilable, when actually if they sit down and properly deal with the issues, and as you said, Tony, there, sometimes the issues aren't even fully understood by the parties involved. There's a very good chance that mediation, workplace mediation, can resolve the problem, can bring the relationship back and make it, make a very positive outcome. I think is probably the way to look at it. And I think it's something that a lot of employers don't give enough time to. Do you think that's fair, Tony, to say that they don't think of it as an option?
Yeah, yes. And I think just to add to that, as I've said, pretty much, I'd say it's an invariably that it's external organisations really bring to the attention of organisations where the conflict is to say enough's enough. So they actually cause the organisations to actually do what they perhaps could and should have done sometimes years previously.
That's it. And I think hopefully what I'm going to now move on to talk about is, I suppose, the slightly more negative approach to resolving workplace disputes, which is, unfortunately, if we do reach a point where the relationship genuinely is irreconcilable, frequently that's going to be turning into an employment tribunal. Now, I'm not going to necessarily be looking at employment tribunals quite so much in how you run an employment tribunal. So it's not really resolving the disputes in that way. What I'm focusing on a bit more, to some extent, is to reinforce Tony's point, really, which is to look at those hidden costs associated with tribunals and the problems and the damage that can arise out of a tribunal. Again, possibly to reinforce that message that if, as an employer, you are just reliant on falling back on an employment tribunal as a way of resolving a dispute, yes, that will work sometimes, but it's a very final position. It doesn't necessarily, well, doesn't really bring the relationship back at all, but it isn't quite as straightforward as just viewing the risk of compensation or the cost of the tribunal. There's a lot more to it. But anyway, so the first stage, which a lot of people will be quite familiar with, is early conciliation. And again, there's a reason here that this is not called early mediation, because unlike, again, what Tony's been talking about, the role of ACAS is not to try and save the relationship as such. It's to find an outcome that works for everybody. And frequently, that outcome really is compensation, usually with termination. So if you have a workplace dispute where an employee can't see a way forward, ACAS early conciliation isn't necessarily going to help bring that relationship back to a positive one. It's probably not going to save that relationship. It may do. That's not to say it can't happen, but frequently the focus of ACAS early conciliation is about ending that dispute, again, usually with a payment by the employer and with most likely termination of the employment so the employee can move on. It is a mandatory process. So again, if the employee wants to bring a tribunal claim, they have to go through early conciliation. So it does give you at least that buffer as an employer. If you're aware that a relationship has become strained or is irreconcilable, you're unlikely to see an employment tribunal simply turn up on the doorstep in the post. It's going to go through this ACAS process first. Now, it actually doesn't necessarily require the parties to engage. So it is possible for an individual to undergo the ACAS conciliation process and indicate that they're not interested in reaching a settlement and simply ask for their certificate number so they can move forward to a tribunal claim. But I have to say that's not very common. Most individuals, most claimants start the ACAS process in the hope of at least achieving an outcome, even if they may have slightly unreasonable expectations on what they might get. So as I said, the way it works for those who haven't been involved in early conciliation is you have an ACAS officer, a neutral third party who tries to broker a deal. They're not legally trained, they're not advisors, they don't really get involved in advice at all. They may give a view sometimes to the parties of their position, strength of their position, potential compensation, etc. But it's not a substitute for legal advice. It's very much seeking to bring the parties together. If you can get a deal, then ACAS can make that a binding deal, so effectively form a binding agreement between the two parties to resolve it. Yeah, they don't try to advise a party as to whether they should take a deal or not. They'll simply try and illustrate it properly to them. The process usually lasts for 6 weeks. That's the sort of normal early conciliation period, although it can end sooner where both parties indicate that they're not interested. As I said, either can refuse, either from the outset, or they can simply withdraw from it, at which point the certificate is issued. A few things to think about early conciliation. It's, for those who don't know this term, without prejudice. Many, I'm sure, will be familiar with it. Effectively, it means off the record. So the negotiations can't be repeated back to an employment tribunal judge later. So if you want to make concessions during early conciliation, then you can do so somewhat in the comfort that it's not going to damage your position later if conciliation doesn't work. But as I put in brackets there, is it genuinely off the record? Obviously, anything you say is to the party who ultimately you may end up in an employment tribunal against. Tactically, it may have a problem for you. If you concede something, it may embolden the other side. It may make them feel that they're more likely to win. So you do need to be slightly careful about what you say, even though it is off the record. If settlement can be reached, again, it's usually done on a no admission of liability basis. Although, again, question, is it really? If your workforce talks to each other, so if they meet up in a social context, or even if they meet up in the workplace, often what I find is rumours of settlements will fly around the workplace quite quickly. So if you do a deal, you pay an employee £5,000 to terminate their employment and for them to leave and to resolve the dispute. You do it formally on a no admission of liability basis, so that's what the agreement will say. But I would say that the workforce won't necessarily see it that way. If it becomes common knowledge that you've paid an employee to go, that's frequently interpreted as an admission of liability, even if it's just in principle, a tacit admission. So it is worth thinking about that in terms of your approach to early conciliation. And again, where it can be a bit of a shortfall, leaving resolving disputes to early conciliation. Even though it's a 6-week process, that's the period leading up to the certificate being issued and the tribunal claim potentially being commenced. But ACAS will remain involved throughout, and I've seen obviously conciliation, an ACAS conciliated settlement being reached right up to the doorstep of the final hearing, sometimes even at the final hearing. Whilst the judge is reading the papers, the parties are still off negotiating through ACAS. As I said, the outcome usually is to bring the employment to an end. Doesn't necessarily happen. You can have settlements where an employee stays on. Often pay disputes can be resolved this way. But if you are going to resolve something like that, you've got to think about the long-term implications. So say, for example, it's a pay claim. Perhaps the employee is saying that the overtime calculation is wrong and they're not receiving sufficient pay in the overtime payments. If you resolve the historical payments through ACAS, you've still got a problem going forward. You've still got to resolve that issue. So you may find that this is an opportunity where the mediation that Tony's been talking about might sit alongside early conciliation through ACAS. So you may have a settlement of historical issues with then a mediated settlement or a mediated agreement of the future, to how the relationship might be managed better in the future to avoid it continuing to deteriorate. So that's early conciliation. We have got a question. I should have said, I put it in the chat box, but if anyone's got them, we will have time for questions at the end as well. Question just from one attendee we've got. Could you please clarify what the meaning of ACAS, if possible? Is there an extensive guide on this process? I suppose the short answer is no, there isn't a guide on early conciliation, not one I'm aware of. The conciliator is assigned when the matter is notified to ACAS by the individual. So the ACAS process, I suppose, very shortly is an individual goes online, fills out a form, that notifies the matter to ACAS. A conciliator is assigned to it and will then contact the individual who started the process, and they will then chat them through what they're looking for and obviously the basis of their claim. They will then have contact details for the employer provided by the individual, and the ACAS officer will then try and contact the employer, obviously through that individual. And that's how the conciliation process kicks off. I think maybe the short answer to the question is just do a quick Google search for ACAS. You'll find a huge amount of information on there. They publish a huge amount on themselves. They also get involved in a lot of other matters. So you may be familiar with things like the ACAS Code of Practice on Discipline and Grievance, which is a published document by them in terms of advised process. But thank you very much for your question. As I said, anyone else who's got questions, please feel free to put them in the chat. But what about judicial mediation? I'll just hold on to that one if I can, just to get to the end. I hadn't covered it specifically in this, but I will cover it for you later. So just to move on and chat about employment tribunals. So again, this is obviously the next step. If your early conciliation is unable to resolve the dispute and you haven't been able to resolve it with early mediation, as Tony's described, you may find yourself in an employment tribunal. And certain occasions, I would say, disputes, it's almost inevitable that you're going to end up in a tribunal. But there's a lot about employment tribunals that I think employers don't necessarily appreciate as to what they're going to find themselves in if it goes that far. And again, certainly the feedback I've had from a lot of clients is that if they had better understood what an employment tribunal was like and what involved, particularly the cost, they would have put a lot more effort into avoiding the breakdown of that relationship in the first place, rather than leaving it to fall apart. So first thing to say, which I think comes as a surprise to quite a few people, is that claimants frequently are not legally represented, and actually frequently have never taken any legal advice at all. Some claimants have sought advice through things like citizens' advice, or perhaps free sessions like we offer here at Machin's to an initial interview to get a bit of a steer in the right direction, but they probably won't have paid for specific legal advice on the law that's applicable to their particular dispute. What that means is you can have a lot of tribunal claims, and in fact, if you look at the statistics, a large number of tribunal claims are withdrawn soon after the defence, or what's in the employment tribunal world called a response, once that's entered. So that's 28 days after a claim has been started and then notified to an employer. So the defence goes in, which tends to be professionally drafted, not always, but quite often. And at that point, the claimant, it's probably the first time the claimant's ever really been provided with a legal analysis of the claim that they're alleging. And it's at that point that they often realise that they aren't going to win their case because the law's just not written in a way that supports their complaint. And obviously you get an awful lot of employees who have a fairly unjustified sense of grievance, perhaps even in a layperson sense, but obviously it's very important when you get to the tribunal. If you can't bring it within the law, you can't succeed. So a lot of claims are withdrawn at that stage. But unfortunately, by that time, quite a lot of cost has already been incurred. The respondent has probably instructed solicitors, taken legal advice, had a professionally drafted response, submitted it, maybe gone through an ACAS settlement as well. And so they probably incurred several £1,000s of legal fees just to get to the point with the individual realising that they can't pursue a claim. And to some extent, that's all wasted. The reason for that is costs, as I've got there, are not generally recoverable. So another surprising, I think, fact about the employment tribunals that a lot of employers, again, are quite shocked by, is that legal fees are not recoverable. So unlike a lot of litigation where the loser pays the winner's legal bill or a substantial portion of it, in employment tribunals, the general rule is that both parties bear their own legal costs. There are exceptions where the tribunal can order costs to be paid to the other side, but it takes a lot more than just a bad case to get that award. It takes really unreasonable conduct on one part, so that might be pursuing a claim that you know you can't win, or pursuing a claim that you put forward facts that are not entirely accurate, but it's quite a high bar. But coming back to that point that claims are often withdrawn at a fairly early stage after a few £1,000s of spend, those costs aren't recoverable. So the employer just has to bear those costs, either if they've got insurance or just bear them themselves, and they're all thrown away. So that's a genuine cost of a dispute, which hopefully can be avoided with early mediation. But again, the total costs, should a tribunal claim go all the way, are usually in the region of £10,000 to £50,000, and even upwards of 50, quite comfortably above 50 sometimes, depending on how complex the cases are. Again, none of that would be recoverable. So you could defend a claim all the way to a final hearing, be told by the judge that you've done absolutely nothing wrong, and that the claimant's claim had never had any hope really of succeeding, and yet you are still left holding that £50,000 bill, and there's no comeback. There's no approach to the claimant to pay for that, and the claimant, who may have been unrepresented, could have incurred no cost at all. So there's something, again, that employers really need to be mindful of when planning their strategy or when dealing with disputes. And again, it's also important to think that actually dismissing claims, so striking out a claim at an early stage. So as I said, a lot of claims are withdrawn by claimants, but not all of them. There are a lot of claimants who are told they have a poor claim and have a poor chance of succeeding, and yet they continue anyway. And a lot of employers, a lot of respondents do want to put pressure on them, and you can make what's called a strikeout application. They are very rarely granted, frequently unsuccessful. And again, that's more cost. Spending time instructing a lawyer, having them prepare the papers, make the application, perhaps present it to a judge, and lose it. That's more money spent. So defending employment tribunal claims, responding to them, is a complicated balancing act of not spending too much money whilst also trying to achieve your other goals in terms of resistance. Obviously, compensation is a big thing to think about. You may lose the claim, so the employee may win. That can be capped or uncapped compensation. I'm not going to go into too much detail about how much compensation employees can get, but it is an important thing to bear in mind that you can lose. It's what a lot of lawyers term litigation risk. You can lose claims simply because your evidence doesn't come across as well as the other. A lot of employment tribunals turn on, to some extent, one person's word versus another. It may be your dismissing manager, and it may be the individual, the employee, who both have a different account of what was discussed in a meeting. And if you haven't recorded it or have notes, and even sometimes if you have notes, it may just come down to how well your manager comes across in evidence. If you lose those claims, you can pay compensation. So obviously, bearing in mind that can be quite sizable, it's another risk that comes with an employment tribunal. But generally, the outcomes of employment tribunals are fairly limited. It's quite black and white. You win or lose, really. There's no middle ground. There's sometimes a lose-lose situation where nobody wins anything, but everyone spent an awful lot of money fighting a claim. That's often where the claimant's lost. But there are no real mediated settlements, much as Tony's been talking about, that are likely to bring the relationship back. Very few employees are going to sue, lose, and then accept the position and decide to just carry on working for that employer. The chances are the tribunal would have made everything much, much worse. Just to stick on employment tribunals, and then I'll come back to a couple of the questions. What I've talked about on the last slide is very much probably the more obvious costs associated with an employment tribunal. So obviously the most obvious one being the legal costs, paying the solicitor's fees to represent. But there are a lot of other costs that are involved in presenting a case to an employment tribunal that a lot of employers don't fully appreciate when they get into it and don't factor in as an actual cost. And these are often can far outweigh the actual tangible cost of the solicitor's fees, and something to bear in mind. So first of all, public hearings, as Tony touched on, you've got ultimately an employment tribunal is going to be heard in public. Very few are heard in private. There is an element of washing your laundry in public, and you bear the risk that that will be damaging to your brand or to your business. Obviously, it is possible that journalists, particularly local journalists, will pick up a story. If they see a big local employer, they may turn up to the hearing. The lists are published, so people do know when big named employers are coming up, and they may write an article about it. You'll also end up with a public judgment. So the tribunal decisions now are published online on a searchable database, very, very easy to find. So you may find increasingly maybe candidates applying for roles with you, searching the name of the company and coming across recent tribunal decisions, and then making decisions about whether they want to work for that employer or not based on what they read in those tribunal judgments. Time is another big one that a lot of employers don't appreciate. You outsource a certain amount of the time to a lawyer, and that's what you pay for in legal fees, but you cannot win an employment tribunal without evidence, and principally that evidence is going to be the managers involved in the dispute, potentially right up to board level and the senior management. And those people will need to attend the tribunal, give evidence to a judge, and be asked questions and challenged on it. And that's a substantial amount of time away from their normal duty. So they should be running the business. Instead, they're focusing on a dispute and obviously putting forward their evidence on that. So management time has a huge cost. Reputational damage, again, I've touched on in terms of the public nature. Fighting claims and winning doesn't necessarily end up in a good reputation either. Unfortunately, you can sometimes, in the court of public opinion, still come off as a loser, even if you're legally okay in what you've done. Again, public opinion might be against you. Judgments, again, I've touched on. In terms of recruitment, they're often also used by other employees in terms of they may read a judgment, see what the argument was, and then use it again themselves to bring another claim. So judgments can be very problematic if it goes all that way. But also, again, thinking about general principles, much as Tony touched on, if the relationship is irreconcilable, if it all ends in a full-blown tribunal dispute, as we've been talking about, and you cannot rescue that relationship, generally what you're going to be looking at doing is replacement. So if an employee is underperforming for some reason, rather than rescuing that relationship, you allow it to fail, dismiss, you end up in a tribunal, you fight the tribunal, you potentially win, but you've still got to recruit somebody else. So you've got recruiter fees potentially to pay. You've got management time for interviews to cover. You've got to wait notice periods. So again, you may have a gap where the business isn't being serviced by that particular position. And again, that can have operational costs that are, again, much wider than the tribunal costs themselves. So it's important to bear in mind not just those direct costs of legal fees, but also those hidden costs, and thinking actually, is allowing this relationship to deteriorate further or to make no attempt to rescue it actually the right outcome. Okay, so we've got a few questions. So I'm just going to jump into these, and then Tony, what I'll do probably is just come to each of us, and we'll just see if we've got anything else to talk about.
Okay.
So I've just got one about judicial mediation as a process, particularly where the claimant party has been so far resistant, reducing huge compensation. Okay, so probably I suppose one more for me, although I suppose, Tony, nothing necessarily to stop that coming into your process as part of it. But judicial mediation, I suppose, very briefly, for those who haven't come across it before, effectively, you have an employment judge. Again, they don't offer an opinion on the case, really. They just talk about compensation. Largely, I find judicial mediation to be focused on, again, trying to achieve a resolution, so trying to agree a settlement. The judges often don't want to hear, particularly from the employer, why they don't think they're in the wrong, why they haven't done anything wrong. They tend to take a view, if you lose, you would be paying this region. So why don't you start with something and work towards a settlement that's better than that? So I suppose the premise of judicial mediation is often assume the employer has lost. But to answer your question, sorry, yes, I suppose it can sometimes help with managing a claimant's expectations. I've certainly seen mediation where claimants come in with vastly exaggerated expectations, and in an hour with the judge talking about it, they've come down, 50%, 20% of what they were asking for originally, because they realise, having spoken to the judge, that they can't achieve what they were hoping to achieve. I don't know, Tony, have you got any thoughts on judicial mediation or alternatives to judicial mediation?
Well, I think perhaps an element I may sort of touch upon is, first of all, even the term mediation is quite confusing, because it covers a whole range of activity, whether it's family, civil, commercial. But perhaps if I just mention the small claim court, that may well be of relevance to more of the people on the call, is and a small claim is a claim under £10,000. So there's a proposal by the Ministry of Justice to enforce what they call compulsory mediation. Now, what's challenging about that as a workplace mediator is the term compulsory, because workplace mediation is voluntary. That's the whole essence of it. But the process is court staff, pretty much untrained, will basically phone up, in this case, parties, because they're going to court, and to see if a deal is to be made. Now, the real fear that I and a number of other workplace mediators have is that you could get mission creep. So first of all, the term mediation, and also the element of mediation itself, because it's about saving costs. So thanks to David, we've looked at the wider issue of costs, and I've touched upon it. But these are some of the real concerns, i.e., what does mediation actually mean? So that's an ongoing discussion, a bit wider than judicial, but perhaps that was relevant at that point, David.
Thanks, Tony. So hopefully that's answered that one. We've got another question about, it's probably slightly moving off topic, but it's under the question of costs, I suppose, for the employer, which is whether or not refusing judicial mediation, I suppose, or wider mediation could be considered unreasonable. So this comes back to that point I was saying in terms of costs and the fact that generally they're not recoverable. You need to show unreasonable conduct on one party in order to recover costs. I suppose the short answer is I've never seen judicial mediation or refusal to mediate as the basis for a costs award. And I think it would be very difficult to say that it is unreasonable conduct not to participate in mediation. Unlike the county courts, as Tony was touching on before there, the obligation in those courts very much is to try mediation, alternative dispute resolution, ways of avoiding a dispute. The same doesn't really apply in tribunals. So judicial mediation is there, it's voluntary, and the principle very much is if you don't want to try it, you can still go to a tribunal. But at the same time, I don't see how, you could, depending on the circumstances, maybe make out an argument that a party had, say, for example, given all the indications that they would try mediation, built all the parties up to it, and then pull out at the last minute. That might be considered unreasonable, but it'd be much more about their approach to mediation specifically, rather than a general view of not interested, as I said, which case I think you'd find probably you wouldn't get costs for that. I think we've answered those. I think the same question maybe was answered as twice. So I think that's the questions we've got at the moment. What we'll do is we've got a couple more slides on some other points. So if anyone has got any more questions, please feel free to ask them. There's a Q&A box. Sorry, it's slightly confusing on Zoom, but you've got a Q&A box and a chat box. If you put your questions into the Q&A rather than into the chat, it's much easier. But there are a few people sharing a couple of comments in the chat box, particularly about ACAS and some of the other guides it's produced. So if you want to have a look at ACAS, there's some commentary in there. But if you have got questions, please drop them in the Q&A, because it's a bit easier for me to pull them out of the chat. So
and
just go on,
David,
Tony, sorry.
I was just going to say, if I could sort of make a point. So there are certain behaviours in the workplace that absolutely cannot be mediated. So effectively, that relates to discrimination, under the Equality Act, and also the implications of that, both for the organisation and the individuals concerned, is unlimited fines. So I just wanted to make that point, that you can't mediate everything.
Thanks, Tony. I mean, I suppose from the point of, I suppose with discrimination, I mean, I suppose it can be settled through early conciliation. So again, you could have a payment through an ACAS conciliation agreement. And obviously judicial mediation could also resolve discrimination. And I suppose if you wanted to, you could also have a settlement agreement resolving it. But as you said, I suppose mediation generally, I guess your view may be more than mine on this, Tony, but discrimination is a very tricky one to mediate because I suppose your starting point is not so much that both parties' views are equally valid. If I put it that way, you may find that actually one party is genuinely just in the wrong. Is that a fair way of putting it?
Yeah, I think if it's possible to say where there is clear discrimination, if I can be permitted to say that, then the ACAS view is very firmly that cannot be mediated. But as you said, David, there's stages under which, as it were, the law can take its place with conciliation, arbitration, let alone a tribunal or the courts, criminal courts. Yeah,
lovely. Thank you, Tony. So just one from us in Machin's here. We've got another webinar coming up in September, Risky Business and Managing Senior Employees. So we're just going to be, Philip and our team is just going to be talking about some of the quirks of managing senior employees, maybe rather than your rank and file employees. So that's promising to be a really interesting one. The slides will come out afterwards, after this webinar as well. So please do use that link if you want to. Just highlighted a couple of bits there about our service. I've got one more question, sorry, just come in. Question for you, Tony. You mentioned making use of icebreakers.
Yes.
Besides not talking about the problem during the icebreakers, what other things do you discuss that can assist young professionals like the person asking this question?
Okay, thank you. So, as I said, so my area of focus is always working with conflicted senior teams. So first of all, it's quite unusual to just mediate two people. But in the icebreaker, and it came back really from my experience in the police of interviewing victims, witnesses and suspects, that I didn't just go cold into an interview. You had to create rapport, trust and a safe space for the other side, as it were, to be able to talk. So recognizing the reality of, and I keep using the word traumatized people, I can't stress that enough, that they are traumatized by years of conflict. And so I recognize that, for example, with ACAS, as with pretty much every other workplace mediator, the first time that the mediator will meet one of the participants is literally just before they're due to start talking about the matters at hand. Now, I thought that was unrealistic, unresponsive and disrespectful to the reality of traumatized people. So I completely separate it. So I separate it by time. So the sole purpose is to develop trust and confidence in the mediation process, also me as a mediator, and for us both to understand each other as people, their experience of mediation, etc. So it develops authentic rapport. It also gives people the time to reflect, and then the feedback I get from, I use the term clients, is that the things that then they're then able to talk about in individual meetings are at a much deeper level, what we call a positional level, rather than how they would originally present. Because it's perfectly possible to, in other types of workplace mediation, for people to, what I'd call superficially engage with the process, but without actually dealing with the underlying issues. And so that's what I've done, both, say, from my police experience. I don't mean I wear a leather coat and shine a torch at people. I don't mean it that, but purely recognizing their trauma so that we can then remove the trauma by creating a safe space so they're fully appreciative of the process and they're fully confident in my ability to listen objectively to what they're going to say. But we absolutely do not talk in the icebreaker stage about the matters concerning mediation. Don't do that.
Thanks, Tony. So just up on the screen is a bit of a summary of all the things that mediations do. Here is, Tony, your details. So if anybody wants to get in touch with Tony, what I should have said is I think a lot of people may have maybe more specific questions, which politely they've held back because I think maybe they didn't want to say too much on a public webinar about them. If obviously you've got any follow-up questions, any particular workplace disputes that you might be going through or see on the horizon, please do get in touch with both Tony and myself. As I said, Tony's details are up there on the screen and there are mine. If you want to book any of our time to sort of chat through them, we'd love to hear from you. As I said, I think my closing word, I'll give the final one to you, Tony, but my closing word is, as I said, anecdotally, I think many of my clients have finished an expensive tribunal and thought, had I known now what I, known then what I know now, I would have tried all my best to avoid this situation. Most employers will only go through a tribunal once. A lot of people will only ever go through a tribunal once, and that's enough, and they never want to do it again. I think, Tony, is that your view? I think very much is best resolved.
Yes, yeah, absolutely. Because I keep mentioning procrastination, and trauma. The two things are linked, and the experience that I've developed, which links back to that the conflict resolution process, is that the manager has an absolutely key role, and that it's incumbent upon all of us to enable managers to manage people effectively and fairly. So again, my own direct experience, both in my previous career and what I'm doing now, is that managers can lack confidence and they will almost divert responsibility straight away to formal processes via HR. So to use the vernacular, HR get a bad rap, and that's not fair, and it's not necessary, and it's not proportionate or appropriate. So exactly as you've said, David, is that early discussion, what I can remember used to be called healthy dialogue, is really, really important. And the consequences of these broken relationships in a business sense absolutely spin across to our private lives. And so it just goes backwards and forwards, because you can imagine if you've had a bad day at home, for example, you go into work, you're not at your best, and vice versa. And it doesn't have to be like that. So thank you, David.
Thanks very much, Tony. So thank you all for your time today. There are no more questions, so I think that finishes our webinar, and I hope you all have a nice afternoon. Thanks very much.